all the judges ready? In Article 1, Section 1 of the Constitution, our founding fathers wisely said that all legislative power herein granted shall be vested in a Congress of the United States. The importance of this principle is emphasized by Dr. Michael Ferris, a lawyer and professor of constitutional law at Patrick Henry College. Quote, "Look at the original text of the Constitution to determine the principle that the founding fathers believed to be the most important. The portion of the Constitution that can justifiably be called the first principle of the Constitution is Article 1, Section 1. All legislative power shall be vested in Congress. The President cannot make laws. The Supreme Court cannot make laws. The executive agencies like the EPA cannot make laws. We should never think that the question, who has the power to make law, is a dry academic question. The founding fathers fought a war over this question, and today, our freedoms are being stolen from us principally because we have allowed various agencies of government to violate this fundamental principle. Only the people or their directly elected legislative representatives have the power to make law." End quote. It is because my partner and I believe in the idea of self-governance that we affirm that the United States federal government should significantly reform its environmental policy. Before we look at how the current system violates the important principle of self-government outlined by Mr. Ferris, let's first examine some resolutional analysis. What is environmental policy? According to the Environmental Education Dictionary, quote, "Environmental policy defines how environmental concerns are approached from a governmental or organizational perspective, often with the goal of addressing and solving environmental problems," end quote. Thus, environmental policies include any course of action taken by a governmental body seeking to steer future environmental decision-making. Now that we have determined the boundaries for the debate, we, the affirmative team, would like to present the goal of liberty as the standard for which we should weigh the arguments presented herein. An affirmative ballot will further the cause of liberty by restoring the founders' intent with regards to the separation of powers. This principle is essential to the liberty of a nation, as stated by Douglas Ginsburg, Chief Judge on the United States Court of Appeals, District of Columbia Circuit. Quote, "Separation of powers, which draws upon ideas advanced by John Locke, Baron de Montesquieu, and Sir William Blackstone, reflects the framers' intention that undue power not be combined in any one department, lest, being unchecked, it become tyrannical. The separation by which each department may exercise only its own constitutional powers is fundamental to the idea of a limited government accountable to the people." End quote. Next, let us examine some of the characteristics of the status quo in Observation 1, background. Currently, Congress delegates its Article 1 powers to unelected bureaucracies. From Jerry Taylor and John Samples at the Cato Institute in 2009, quote, "As long as Congress articulates some intelligible standard, no matter how vague or arbitrary, to govern executive lawmaking, courts are prepared today to allow delegation, in the words of Justice Cardozo, to run riot. John Locke's admonition that the legislator cannot transfer the power of making laws to any other hands, for it being but a delegated power from the people, they who have it cannot pass it over to others, is a forgotten vestige from an era when individual liberty mattered more than administrative convenience. As Federal District Court Judge Roger Vinson wrote in United States v. Mills in 1989, a delegation doctrine, which essentially allows Congress to abdicate its power in favor of an unelected administrative agency, does violence to this time-honored principle. Yet that seems to be the state of the law." End quote. It is because the law has been thus corrupted that my partner and I propose the following plan in Observation 2, the plan. Agency, Congress and the President. Mandates. 1. Environmental rulemaking authority will be denied to all federal agencies. 2. All past environmental laws and regulations passed by the EPA will be reviewed and voted on by Congress. Funding. No additional funding is needed as this plan is purely legislative. Enforcement. Federal courts will strike down any violations of this plan. Clarification. The EPA will still be responsible for enforcing all environmental laws passed by Congress and will still be able to give advice to Congress. Observation 3. Justifications for change. Justification 1. The current system violates the Constitution. From the Cato Institute, prepared by Edward H. Crane and David Boaz in February 2001. Quote, "The Constitution clearly grants to Congress the power to make laws and to the executive branch the power to execute the laws. That separation of powers is a key element of the constitutional design. The founders feared nothing more than the concentration of powers in one set of hands. But, since the 1930s, Congress has gotten into the habit of passing broad laws and leaving the details up to administrative agencies. Congress cannot constitutionally delegate its lawmaking authority to any other body. Congress should accept its responsibility for making law and cease delegating legislation to the bureaucracy." End quote. An affirmative ballot will end blatant disrespect for the Constitution by restoring the separation of powers principle. Justification 2, liberty infringed. From the Cato Institute by David Schoenbrod and Jerry Taylor in February 2001, quote, "The concern over congressional delegation of power is not simply theoretical and abstract, for delegation does violence, not only to the ideal construct of a free society, but also to the day-to-day practice of democracy itself. Ironically, delegation does not help to secure good government, it helps to destroy it," end quote. By restoring the principles of self-government, liberty is furthered with an affirmative ballot. Justification 3, executive regulation. From the Cato Institute by David Schoenbrod and Jerry Taylor in February 2001, quote, "Perhaps the ultimate check on the growth of government rests in the fact that there is only so much time in a day. No matter how many laws Congress would like to pass, there are only so many hours in a session to do so. Delegation, however, dramatically expands the realm of the possible by effectively deputizing tens of thousands of bureaucrats, often with broad and imprecise missions to go forth and legislate. Thus, as columnist Jacob Weisberg has noted in The New Republic, as a labor-saving device, delegation did for legislators what the washing machine did for the 1950s housewife. Government could now penetrate every nook and cranny of American life in a way that was simply impossible before," end quote. By ending delegated legislation, we limit growth of government while preserving liberty. Justification 4, cap and trade and the tyranny of law corrupted. From Gene Healy, Vice President at the Cato Institute in September 2009, quote, "In a democratic country, you'd think that before the executive branch could regulate CO2, the legislature would have to vote on the issue. But you'd be wrong. In 2007, the Supreme Court ruled that the 1970 Clean Air Act's definition of air pollutant was broad enough to allow regulation of CO2 emissions from new cars, and that the EPA was required to regulate once it issued a finding that CO2 contributes to global warming. In fact, once the EPA rules that CO2 is a dangerous pollutant, as it did in April, regulation of industrial sources likely becomes mandatory as well. But existing law still leaves the executive branch enormous discretionary power and thus a hammer to hold over Congress's head. A report issued in April by the New York University Law School argues that if Congress fails to act, President Obama has the power under the Clean Air Act to adopt a cap-and-trade system. James Madison believed that there could be no liberty where the legislative and executive powers are united in the same person, and yet here we are," end quote. An affirmative ballot will end the tyrannical actions of the EPA in regards to cap and trade, allowing representative government true control over what laws govern America. In light of the aforementioned reasoning, and in order to further the cause of liberty, we urge you to correct current misinterpretation of the Constitution by affirming the resolution. Thank you.
Great. Does the Supreme Court ever make mistakes in their rulings?
They do.
All right, how about, would you believe that the Massachusetts versus EPA decision in which they mandated that the EPA accept delegated rulemaking from Congress, was that a mistaken decision?
Well, it was based upon faulty decisions in the past, faulty precedent. And because it was based on faulty precedent, it itself was faulty.
And you also, I believe, you mentioned that the Supreme Court had allowed the cap and trade policy or the proposal to actually advance. Was that also a mistaken decision?
It didn't necessarily specifically allow cap and trade. What it did is it mandated that the EPA regulate CO2 if it finds it to be dangerous, which it did.
And that was a mistake?
That was a mistake, yes.
All right, now let's talk about the role of the Supreme Court. Under the Constitution, what role does the Supreme Court have in determining the constitutionality of given actions?
Well, the Supreme Court is supposed to interpret the Constitution.
Okay. And if undelegated rulemaking is unconstitutional, why hasn't the Supreme Court struck it down?
Well, the Supreme Court in recent years has shifted from interpreting the Constitution based upon the original intent to interpreting it based upon what they feel is necessary.
All right, so basically the Supreme Court right now is the reason why your case is even existing, because they are ruling it in improper manner.
Because the Supreme Court has decided that it is constitutional.
Now let's move up to your goal, talking about liberty. Would you agree with me that upholding the Constitution and primarily original intent with regard to this delegated rulemaking issue is the primary means of achieving liberty?
Through the separation of powers.
Sure, separation of powers. Now, you'd agree with me that separation of powers means that each branch of government only deals in such a way that the Constitution gives them the
Correct.
power to act.
Mm-hmm.
All right, now let's talk about your background point. You said that Congress delegates rulemaking. Now, was this piece of evidence specific to environmental policy rulemaking?
I don't believe it was specific to environmental policy, but they do delegate with regards to environmental policy. Clean Air Act is it.
Is delegated rulemaking, say, to the Internal Revenue Service a problem from a constitutional perspective?
Potentially.
How about the Department of the Interior?
Potentially.
Okay, just for the purposes of this round, is it the affirmative's contention that all delegated rulemaking is bad, or that only environmental delegated rulemaking is
We're
bad?
looking specifically at environmental policy because that's what we're allowed to look at under this year's resolution.
Suppose for a second that a resolution didn't exist and we were looking at delegated rulemaking as a whole. Is all delegated rulemaking bad?
I personally haven't examined other examples of delegated rulemaking, so I don't feel qualified to answer.
Thank you so much for your time.